focus today is on the Disability Discrimination Ordinance and the rights and remedies that are provided to it across a range of sectors. My key sector is employment law, but also it covers goods and services, access to premises, and education. So what we're going to cover today is the Disability Discrimination Ordinance and its protections, focusing on employment rights. We're going to deal with some education rights as well, and then how you enforce those rights via the Equal Opportunities Commission and how that operates, and court remedies. The Disability Discrimination Ordinance was implemented in 1995. And very unusually for Hong Kong, instead of following the UK legislation, we decided to copy the Australian legislation. And the upside of that was that the definition of disability is far wider. In the UK, disability has to be long-lasting or expected to be long-lasting, which is 12 months. And also it has to be a diagnosed, how do they phrase it? It has to be a clinically well-recognized disability in order for it to be protected. The Australian definition is much wider and is basically all-encompassing for any form of mental or physical disability. The ordinance not only covers people who have disabilities directly, but also covers people with associated disabilities. So that is if you're the carer, parent, or guardian of somebody with disabilities, and also imputed disabilities. And so if you're not disabled yourself, but somebody believes that you might be, and then discriminates against you as a result of that. And so it extends very broadly. Okay, so the three headings that are protected against would be discrimination, which can be direct or indirect discrimination. Direct discrimination means that you've suffered directly as a result of your disability. The most obvious one in an employment context is people who are terminated or people who are not hired as a result of their disability. There's also indirect discrimination, which means that an employer or an organization is applying a criteria across the board which doesn't have a justifiable reason to it, but indirectly discriminates or excludes certain people. The next heading is harassment, which is fairly self-explanatory. Harassment is unwelcome conduct. And then the third section that's protected is vilification. The easiest way to understand vilification is usually either retribution or retaliation. And so if you've assisted somebody in connection with a disability complaint, you've made a complaint yourself, you've appeared as a witness for somebody in connection with a complaint, then you're not allowed to suffer retaliation or retribution as a result of assisting that person. So what constitutes a disability under the law? As I said, we're using the Australian definition, which is much wider. One of the other things that we need to bear in mind, because our legislation is based on the Australian definition, is we can't really look to UK case law to assist us. Concepts of direct and indirect discrimination exist in UK case law now, but the definition of disability itself is still much narrower in the UK than it is in Hong Kong. And so the types of disability covered are physical disabilities, mental disabilities, intellectual disabilities, learning difficulties, and chronic illness. Importantly, a disability does not need to be long-lasting. A disability can be short-term. So if you're suffering from a short-term sickness, you could be disabled during that period of time. Similarly, the disability doesn't need to be diagnosed. And so if, for example, in an employment context, somebody is obviously suffering burnout, somebody is pleading for help, somebody is saying that they're stressed, they can't cope, etc., then an employer should be on notice that that person could be disabled, even though that person hasn't gone to the doctor and received a clinical diagnosis to say stress, anxiety, etc. They could still be protected. So disability does not need to be diagnosed. And as we'll come on to a little bit later, the extended protections to associates and imputed disability. So we can see the 6 areas that are primarily protected, with employment and education and goods and services access to premises being the key areas that affect people in day-to-day life. With respect to employment, which is probably the most important area, the government's issued a code of conduct, and they've also issued an independent code of conduct for education as well. A code of conduct is essentially guidelines issued by the government, which are not legally binding in the same way that the statute is, but the Equal Opportunities Commission and a judge, if the matter went to court, would consider compliance with the code of conduct when assessing whether there was unlawful action or not. The other benefits of a code of conduct is it's much easier for a regular person and lawyers actually to just read and understand what the legislation's hoping to encompass. Legislation's a very difficult thing to read, whereas a code of conduct explains things, it bullet points, and it sets out some examples. Being what it is, the Hong Kong government's examples are not very imaginative. A lot of the examples that they use tend to relate to wheelchair access to premises and the like, which aren't particularly helpful in understanding how the ordinance applies to certain mental health conditions. Although the ordinance is intended to protect against discrimination, it does have important exceptions. And it's the exceptions that tend to confuse people and lead to the most litigation and controversy. The exceptions that apply across the board is the need to provide a reasonable accommodation, and then relying on what's called unjustifiable hardship in order to say, I appreciate that what we're doing is discriminatory, but it would cause me an unjustifiable hardship to change what I'm doing as to make it non-discriminatory. And that can then be used as a defense. And so looking at this in an educational context, educational organizations are obliged to make reasonable accommodations to their programs, services, and facilities in order to meet the needs of all students, including students with disabilities, unless that presents an unjustifiable hardship. Essentially means that it would be too difficult, assessed against a number of sort of criteria metrics, to provide an accommodation to facilitate access by a disabled person. The example that's always given is if you have a historical building where it's got staircases, and for whatever reason, because of the nature of the building, it's impossible to install a lift. Then that would deny access to certain floors of the building from somebody who's not ably-bodied, and that could be used, the unjustifiable hardship exemption could be used as an excuse, as a defense for denying access to those people. When assessing what would be, or whether something is actually an unjustifiable hardship or not, a whole range of criteria are assessed, with cost, fortunately, being the least important one. And so the practicality being able to make the accommodation, whether that accommodation would benefit more people than not. A ramp, for example, benefits everybody because everybody can use a ramp. If you're carrying heavy bags, a ramp's useful, et cetera, et cetera. And so it's not a single purpose accommodation, it's a general accommodation. And if you want to rely on this defense, then the organization which is saying it's unreasonable hardship would need to justify that. I think it would be easier explained with a case study. As I say, the government case studies are less than ideal, but taking a case from Australia, it explains in which way the unjustifiable hardship exemption could be used. And so in this case, there was a 7-year-old girl with intellectual impairments who had poor communication, gross motor skills, and self-care ability. The girl was in kindergarten special needs education and then moved on to primary. When she went into primary, her mother very much wanted her to be part of a mainstream school. And the school admitted the child, but then very soon after the school year started, she was excluded from the school. And the two teachers that she had no special training and said that they just could not cope with the child in the classroom and look after all of the other children, etc. The classroom had a teaching assistant and it had a once-a-week special needs coordinator. But with those accommodations, it still wasn't enough for the teachers to be able to sort of suitably care for the child in the classroom environment and look after the other children. A guidance officer was invited into the school and recommended that the child should go into special needs education. And the mother refused. The mother wanted her child to remain in mainstream education. The child was ultimately expelled from the school and the mother sued. And it went to the Queensland Equal Opportunities Tribunal and they assessed the case based on a series of criteria. and came to the decision that although what was happening was discriminatory, there would be an unjustifiable hardship if they forced the school to accept the child. In arriving at that decision, they basically concluded that there were no special needs teachers in the school that could care for the child, and it would be unreasonable to impose special needs education training on the two current teachers, that the burden on the other students in the classroom would be too high, and that as an overall conclusion, the best environment that the court decided for the child would be to be in special needs education rather than mainstream education. And that outweighs the discrimination protection that the ordinance should provide. And so the same application would be considered in Hong Kong. That being said, we have a number of examples in Hong Kong which are much more positive. One of the examples is where a child with autism was admitted to school, went through the school interview process, and the school accepted the child. After a week or two, the school found the child to be too disruptive and essentially asked the mother to withdraw the child from the school. The mother objected and brought proceedings against, issued a complaint with the Equal Opportunities Commission against the school. And the Equal Opportunities Commission, if you like, upheld the complaint. The school was well aware of the child's needs. They admitted the child, and they did nothing to consider what reasonable accommodations could be made during the couple of weeks before they asked the mother to withdraw the child from the school. Sensibly, I think, the mother did change schools. I don't think it would be very convenient to sort of continue with the child in the school, essentially after you've sued the school and the teachers. But she did receive an apology and some compensation. And a very similar case existed with a child who was admitted to a school, again following an interview process, with attention deficit disorder. In that case, the child was at the school for the whole school year. And the particularly egregious problem that the mother had with this, and I totally understand it was a week or two before the end of the school term. The school said, look, your child's too disruptive. We can't cope. Can you please take your child out of this school and find another school? Anyone with children will know finding another school for your child with 2 weeks' notice before the end of the term is pretty impossible. She also made a complaint to the Equal Opportunities Commission, and she received financial compensation, reimbursement of her school fees, and an apology as well. I don't propose to focus on services because we've got very limited time. But just to demonstrate how the Equal Opportunities Commission has considered complaints relating to people being denied services. There was a case with a child who also had autism and attention deficit disorder. And I believe it was a shopping mall, although they're not particularly clear in the case study. And the child essentially lost control and had a breakdown in the shopping mall. And the mother took the child to a corner and was playing with the child, trying to care for the child and just calm him down. Whilst this was happening, a security guard came over and demanded that the mother leave the shopping mall with the child because it was being too disruptive. The mother tried to explain that just give her a bit of time. She needs to calm the child down. It's all fine. It's not disruptive. They're out of people's way. Security guard then escalated matters to say he was going to call the police to have the child taken off her and taken to hospital. Obviously, this was very distressing. The mother sued the premises owner because the security guard is an agent, an employee of the premises owner or the management operator. And it's therefore they are vicariously liable for the acts of their employees. And in that case as well, the Equal Opportunities Commission conciliated, compensation was paid, and an apology was given. Moving on to focus on employment-related discrimination. There was a report in the SCMP last week that the number of cases in 2006 have already doubled the number of cases in 2001. The Equal Opportunities Commission was asked to sort of opine on why they think that there are so many more cases in 2006. And a reasonably classic excuse to sort of sort of get out of jail excuse for these things is to say it's public awareness. More people are aware of their rights. More people are willing to speak up. I doubt that severely. The legislation has been on the card since 1995. People have had the internet since 2000. With Me Too, which I appreciate was a different issue, people have become much more willing to speak up for at least the last 10 years. And so I don't really think that a lot's changed between 2001 and today that would cause people to be more willing to exercise their rights. I think it's probably due to the fact that declining economy, use of AI, and people are basically looking for ways to make staff redundant and terminating disabled staff. It tends to relate to mental illness, staff that are suffering absence due to stress, anxiety, burnout. Employees find ways to make them redundant to justify the dismissal. And it can be done, but if you don't do it very smartly, you will come undone and people will enforce their rights. The ordinance includes an inherent requirements obligation. And so again, it is possible to discriminate against somebody if what you're requiring, the inherent requirements of the job, are that that person must not have that disability or must not have any disability. A very obvious example would be a wheelchair user could not be a fireman. And so that would be an inherent requirement of the job. And as we'll come on and see, people have tried to use this in a variety of circumstances and come undone because the government will very closely scrutinize whether you actually do need to meet whatever the requirement is set up. And they will also expect an employer to make reasonable accommodation. And you can rely on unjustifiable hardship, but in a lot of cases, a reasonable accommodation is not that difficult. An issue which is very prevalent in the UK at the moment, Australia, the US, and probably around the world, is managing people with diverse needs in terms of anxiety, stress, attention deficit disorder, who would find it difficult to comply with certain employee policies that are in place. But why are those policies in place and why would that person have to follow that? Why would it be fair? And one of the questions I got asked by a major employer would be, an employee has challenged the sick leave policy that says that they must phone in half an hour before their shift is due to start if they're unwell. And the employee said, look, the reason I would be unwell is because of intense anxiety, and being required to phone in and report that I can't come in today actually exacerbates the anxiety and makes things worse. You're a huge organization. All organizations are incredibly technically astute. Why could we not send a text message, send an email, use an electronic means? Why would I need to phone in? And we went through the legislation. We considered the guidance from Australia and, to contradict myself, the UK. And it's right. There was no justifiable reason why that person needed to phone in to report sickness rather than using some electronic means. Related back to the issues today in connection with how the ordinance sort of extends to protect families and families who have disabled children. As I said, it extends to cover accommodation. And so if you are the carer or guardian of a disabled child and you get discriminated against because of that, then you've got recourse. And also if there's an imputed disability. Fortunately, the imputed disability doesn't crop up as much as it used to. The classic example that happened all the time was 20 odd years ago when HIV was still an incredibly scary, slightly unknown, and a condition that people suffered a lot of discrimination. And if somebody had an HIV positive family member, members of the family if they found out about that, if an employer found out about that, service employer found out about that, would refuse access or employment to extended family members. And so even though they were not disabled, they would still have protection under the ordinance from discrimination. Two particular cases were handled in Hong Kong that related to both associated and imputed disability. And they weren't that long ago, and yet they read like something from like the 1970s. Also, bizarrely, the organization that was discriminating was the government. So it was a government department that the person applied for a job for. In one of the cases, somebody applied for a job, and his brother had schizophrenia. And somehow in the application process, he disclosed that his brother had schizophrenia, and he was rejected the job. He applied for the job again, and this next time he wasn't even considered for an interview. And I don't know why he became alerted to this, but he felt that the reason why he hadn't got the job was connected to the fact that he disclosed that his brother had schizophrenia. And the government said, yes, that's the reason. But it's a really, really stressful job. And then ran a really blended, weird defense of, well, you might be schizophrenic, have a propensity to schizophrenia, and therefore we can't hire you for this. Or it's a really stressful job and you've got to care for your brother, so you won't be able to focus on your job because you'll be caring for your brother. Needless to say, that was roundly criticized. The complaint was upheld, and the person received, again, compensation and an apology. And then another case, again, unbelievable that this one actually happened after the other one, after the one we've talked about, where something very similar happened, but this was on the grounds of his father's mental illness. And the organization said, if your father has a mental illness, we think you might have a propensity to mental illness, and therefore you wouldn't be able to do your job. And so that's the imputed discrimination. And then they also tried to run the argument, of course, you'll have to care for your father. Again, very, very similar facts, roundly criticized, upheld as being discriminatory. I think in that case, received financial compensation of 275,000 for injury to feelings, loss of earnings, accrued interest, and an apology. And so fairly significant financial compensation outcome for what strikes me as just absolutely ridiculous grounds for seeking to discriminate. The case studies that we've talked about all arise from reports made by the Equal Opportunities Commission. I'll leap ahead and then I'll explain why I think the Equal Opportunities Commission is very important. If you wanted to sue for discrimination in Hong Kong, you have to do that in the district court. And although the district court has a truncated process, the Equal Opportunities consolidated process, I forget what it's called, which is a little bit quicker than normal district court legislation, you could still expect a case to go from being issued to trial to take 2 to 3 years. At its quickest, assuming it's going to be defended, you can expect to spend 500,000 to $1 million Hong Kong dollars, especially if it goes to trial. A trial could last 6 or 7 days. You would probably instruct counsel. You'd have solicitors. It's full wigs and gowns. It's not sort of the easy light tribunal like the Equal Opportunities Commission. And so that really discourages people from bringing cases. Also, with the best will in the world, the government said, if you bring an equal opportunities case, the usual rule of costs follow the winner, so the winner gets their legal costs paid for them, doesn't apply unless certain hurdles and exemptions can be covered. On one hand, that's good because it means that you can bring a complaint and you're only responsible for your own legal costs. And if you lose, unless you've behaved unreasonably or abusively during the legislation, you wouldn't have to pay the other side's legal costs. But when compensation for injury to feelings is 270,000 Hong Kong dollars, and you spent 500,000 on your own legal costs that you can't recover, there's not really a lot of financial incentive to bring complaints, which is why we see a handful of complaints being made in the district court each year. You can tell how many because they all get given a little DCO reference and then a number. And if you file a complaint in December, you could quite easily be case number 10, 12, 15. And so the very, very few cases get issued each year. And I think it's because of the financial penalty that attaches to that. To sort of go back on myself, the Equal Opportunities Commission was essentially set up as a body to promote equality, diversity, to implement anti-discrimination legislation and to enforce it. But also day-to-day for you and I, what it does is if a complaint is made, it conciliates that. Well, it investigates that complaint and conciliates it. It's a slightly unusual process that it takes. There is a threshold to making a complaint. They have to accept that there's at least a prima facie case. And so it's not like a case that you start in the court or the Labour Tribunal where you issue your case and the court has to deal with it. There's a little bit of a sort of sifting and vetting procedure. And sometimes I can find that the EOC is very conservative. And so if the case isn't very obvious, they might not be prepared to take it on board, or you might really need to push like 5 or 6 letters, further evidence, et cetera, just for them to accept the case. But when they accept it, they move reasonably quickly to try and settle it. And if you're not prepared to settle it in what they call early conciliation, they will then investigate it. Investigation tends to be a paper exercise, backwards and forwards, asking for evidence, witness statements, and the like. And then they come up with a finding. And the finding is not a judicial finding, so they can't impose a penalty. But what they can do is they can say, we believe that discrimination has happened, or we believe that discrimination hasn't happened. Tends to be slightly in the grey, the way that they conclude these things, rather than absolutely we think you've been discriminated or absolutely we think you haven't. And then what the EOC can also do is provide legal financial assistance for you to pursue your case through the district court if they believe that there's good grounds for discrimination. It's not quite like legal aid, but if you're an incredibly rich person, they probably won't provide you with assistance. If you're of limited means and there's obvious discrimination, then you probably stand a good chance for qualifying for the legal assistance. Okay, so jumping back to the court, what can you ask for from the courts if you have been discriminated against? From the cases that we mentioned earlier, a lot of people who bring cases really do so because they want justice. It doesn't tend to be about money. They're going to spend a lot of money on this. And so recognition that they've been discriminated against, an apology, the courts can issue a direction to tell an employer, an organization, stop discriminating, improve your policies, implement training, et cetera, et cetera. So they can do a lot of non-monetary remedies can be ordered or ordered against the party that's doing discrimination. And then there are also 2 aspects of financial compensation you can claim. The first is actual economic loss, which basically means in an employment context, if you've been sacked, how long will it take you to get another job, or how long will it reasonably take you to get another job? They're quite conservative. They would expect you to get another job within about 3 to 6 months. And so that compensation is pretty limited, unless you can show why, for some reason, it would take you longer than that. And then there's compensation for injury to feelings. And the way that compensation for injury to feelings is determined is based on a UK case called Vento. It was the West Yorkshire Police versus Vento, where the courts invented these 3 bands, lower band, middle band, and upper band. And then with each band, there's lower band, middle band, and upper band within each. And so there's sort of 9 bands in which it's determined. And they attached financial values to each of the bands that they then increase each year. So the lower band would be, translated from Hong Kong dollars, about 70 to 150,000 Hong Kong dollars. Middle band, 150 to 300,000. And then upper band up to about 500,000 Hong Kong dollars, with the ability to award punitive damages in exceptional cases. But it very rarely happens. And the few cases where Hong Kong has awarded punitive damages, it's really only a sort of $100,000 or so or more. And so that's the way that the financial compensation is determined. And as I say, the very limited compensation that you can recover against the costs of bringing legislation discourage and put people off, which is one of the unfortunate reasons why we have very little case law in Hong Kong to guide us on this. And I think with very little case law, we then get very little sort of public exposure to people doing wrong in order to sort of embarrass people into getting things right. If you do have a discrimination complaint, there are very, very strict limitation periods on which you need to bring the complaint. And so the Equal Opportunities Commission will very rarely entertain any complaints that's more than 1 year old. The district court is barred, apart from very exceptional circumstances, from considering complaints that are more than 2 years old, with a really confusing rule that sits in the middle, which is if you issue a complaint in the Equal Opportunities Commission, the clock for bringing the case in the district court stops. And so the time that's spent investigating your case formally by the EOC doesn't count towards that 2 year period, provided the EOC conclude the case within a year. And so it sort of extends it to 3 years, but sort of not. And there's also a weird little rule in there that says the EOC needs to issue essentially a certificate to say when they've concluded the case. But the EOC doesn't issue these certificates. And so it's very difficult to know when the stop the clock rule starts and finishes. And it doesn't relate to disability. There's a sex harassment case where this was a huge issue, where no one knew where the limitation periods ran. Arguably, it went back 3 years. Arguably, it didn't because of the stop the clock rule. And so, to be perfectly honest, if you have suffered discrimination, you know anybody that suffers discrimination, speak up sooner rather than later. A year passes very quickly. The year doesn't kick in until the EOC accepts your complaint. And as I say, sometimes you need to really push at the door in order to get them to take it. And that can take months. It takes them a while to review everything you've sent. It takes them a while to come back with questions. It takes you a while to answer those questions. And so don't leave any of these things to the last minute. And certainly if you're going to start a case in the district court, very, very much focus on that 2 year rule. And then very, very carefully consider whether you can extend it because of the stop the clock provision, because you can leave yourself without any remedies, even if you have obviously been discriminated against. And on that note, happy to take any questions now, or happy for us all to do questions at the end. Excellent. Thank you very much.
So my section is on a rather limited scope, as divorce with a specific focus on children. Now, it's very important to keep in mind that this is a narrow scope, because once you're outside the context of divorce, different children law applies. So these are the topics that I will basically go through. We'll talk about the jurisdiction of the courts, the definition of children in the context of divorce, the care arrangements, how the courts make the decisions, briefly touch up on maintenance for children, and lastly on legal aid. All right. In order to invoke the family court's jurisdiction, there are only 3 grounds. All right. 3 grounds only. The first one is domiciled. The second one is habitual residence. And lastly, substantial connection. These are quite heavy topics if we want to go in depth, because there are lots of case law on that. But in gist, if one party lives in Hong Kong, all right, if one party lives in Hong Kong, basically the Hong Kong court would have jurisdiction to deal with the divorce, even though the kids are not in Hong Kong, or if the parties do not conduct their married life in Hong Kong. From another perspective, where you get married does not matter, right? There is always a misconception that, oh, I was married in Hong Kong, so therefore I can invoke the family court's jurisdiction. No, that is not correct. Even though you are married elsewhere, so long as you fulfill one of these criteria, then the Hong Kong court would have jurisdiction to deal with the divorce. domicile essentially is the intention to reside in a particular jurisdiction and actually lived in that jurisdiction. It's a technical legal concept, right? So, but basically, if you are born and raised in Hong Kong, you are domiciled in Hong Kong because you treat Hong Kong as your home. To give another example, you can change your domicile in theory in an instance. So let's say I decided to relocate, right? I applied for citizenship in a particular jurisdiction and I land in that jurisdiction. So once you land in that jurisdiction, in theory, the domicile has changed, right? So domicile is a highly technical legal concept. Habitual residence is more straightforward. And the requirement is that you have to habitually reside in Hong Kong for a continuous period of 3 years. Right? 3 years prior to the filing of the application, you have to habitually reside in Hong Kong. And substantial connection is probably the most difficult and most challenged grounds because the definition is quite loose. There is no hard and fast rule as to what amounts to substantial connection. But the case law, it's usually says that even though you have Hong Kong ID, even though you have landed properties in Hong Kong or companies in Hong Kong, that itself might not be sufficient to say that you have substantial connection to Hong Kong. So the basic rule is that you have to at least live in Hong Kong in order to attract the Hong Kong court's jurisdiction. But the key point is that only one party to the marriage has to have one of these. So it doesn't need that, both parties have to be domiciled in Hong Kong or both of them habitually reside in Hong Kong. Either one of the parties will do. This is a rather unique feature in divorce law, is that we are not only talking about biological children. Okay, the definition of children of the family extend beyond child born to both parties and extend to any other child who has been treated by both parties as a child of the family. The recent case law on this even expand to surrogated child. All right, so long as the parties treat this child as their own and raise them and provide for them, then it's likely to be children of the family. And the family courts can then deal with the child. However, the Hong Kong family court can only make children arrangement order before the child turns 18. Or I should say that any order made in relation to children will cease to have effect if the child turns 18. Okay. All right. This is probably one of the most important slides in the whole presentation. That is, what would the court do or what order the court would make when it comes to children arrangements. Unless and until Hong Kong has a law reform, we are still using very archaic orders, being custody, can control, and access. So this is probably, again, the most important slides when it comes to children matters. Very often, people mixed up these concepts. And they say that, I actually want custody, but actually what they meant is that they want can control. Because custody simply refers to important decisions of a child. That is, for example, which school to attend, the religious beliefs, or where to stay, like whether it's Hong Kong or different jurisdictions. So this is the important decision of a child. Whereas custody and access, I would view it together as merely division of time. So the more time you spend with the child, you have can control. The other party who spend less time will have access. There is no fixed way as to how the courts make the arrangements. There can be all sorts of arrangements. The court has unfettered discretion as to how to make care arrangements and access. So you might have the extreme case that the parties have shared care and control because they can communicate with each other or cooperate well with each other. So roughly, we can have arrangement that the kids will spend equal amount of time with both parents. To the other extreme, that the one party may only have email access, for example. So the range is very, very wide. And also in relation to custody, there can be joint custody or sole custody. Now, joint custody simply refers to both parties making the decisions together, whereas sole custody means the parties who have sole custody can make the final decision. From a legal perspective, joint custody and sole custody might not differ that much, because even if you are the sole custodian parent, you have the legal obligation to consult the other party. All right. So that means if the parties are not on the same page or can't make the decisions, or they have different views, they will end up in court. Right? Whether it's joint custody or sole custody, they are likely to end up in court. So from a legal perspective, it might not differ that much, but I must say in practice, there from time to time might be differences or advantage in having sole custody. The one of it being that in case of emergency, so in the extreme case where the mother, say for example, the mother and the child relocated elsewhere, okay, the father is in Hong Kong, and in the event of a joint custody, if there is any medical emergencies, the hospital might ask for the consent of the father in some rare situation. So in those cases, sole custody might help. All right. And my experience is that some schools or some passport applications, it might be easier if you are the sole custodian parents. Might be. Okay. So that is the three important concepts when it comes to children arrangements. There's an important note here, which says that the court's jurisdiction in divorce ceases when a child turns 18. So the question is, well, what happens if the child is after the age of 18, but with special needs, for example? Unfortunately, family courts doesn't treat disabilities in such a way. So long as you're 18, then the court ceases jurisdiction. When it comes to children arrangements, all right, in the context of divorce, if the child, for example, is mentally incapacitated or somehow falls within the mental health ordinance jurisdiction, then we can invoke the High Court in relation to that jurisdiction to deal with the child in that regard, but not in the context of divorce. And another thing to keep in mind is that these orders can always be varied until the child turns 18. So this is one of the reasons why the family courts are so busy, because a case can potentially never end until the child becomes an adult. Okay. However, this makes sense because children's needs varies as they age. They might have for example, if you can imagine if it is a newborn versus a child that is 15 years old, the access arrangement would be very different. So it only makes sense that the court retains jurisdiction over children's matters. So we talked about how the courts, what sorts of orders the courts would make. Now this slide talks about how they made that decision. The guiding principle is very simple, yet complicated. The guiding principle is that we make children's arrangements in accordance with their best interest. Simple enough. But what is best interest? That is the $1 billion question. So what the court would typically do when it comes to dealing with children arrangements is that they will call for social welfare reports. So the social welfare officer from the social welfare department would then do the investigation. They will do home visits. They might go to the school and talk to the teachers, talk to all the carers, and then make recommendation to the court. So they are essentially the eyes and ears of the court. So if the kids have special needs, in theory, then you will have to, the social worker, when talking with the carers, will also have to document all these special features of the child. Now, because the courts are not medical professionals, in certain cases, the typically more complex ones, if the child has mental, or if the parties thinks that the court needs additional help apart from social workers, then they can also request psychologists or psychiatrists for help, right? Then they will prepare additional reports apart from the social welfare reports. Apart from the social welfare reports, there are certain, I won't say guiding principles, but certain principles that the court would typically follow, especially in Hong Kong. In Hong Kong, we rarely would split up the siblings, unlike in China. They would see that siblings growing up together are generally in their best interest. But it doesn't mean that the court are not prepared to split the kids, but only in rare circumstances. And if the parties can justify it, or if they can convince the courts that it is in the kids' best interest to do so. Now, I have seen this happen. It's a relocation case that I've done years back. There are two sons. And the courts at the end made the ruling that they will only allow the mother to take one of the child overseas, and the father and the other son remains in Hong Kong. The rationale of the court is that after weighing up all the factors, all the evidence, the court felt like the parents are not capable of looking after two kids at the same time. So the court felt like that splitting the kids in that particular situation is best for them. All right. So from time to time, you do see examples where the courts are prepared to, separate the siblings. But this is definitely not the norm compared to, for example, in the PRC, where they are more likely to do so. Now, my personal view is that because in China, typically the parents are living in different provinces. So the differences can be quite far away. And if both of the parents, if the kids are living with one parent, basically the other parents can rarely see the kids. But in Hong Kong, we doesn't have this geographical limitation because it's so small. It's very difficult. It's very easy to exercise access despite both kids or whoever, all the kids are living with one parent. And in the left bottom corner, it says access is the rights of the child. This is very important to keep in mind that in Hong Kong, the court is concerned with the best interest of the child. It's not what the parents want, it's what is good for the kids. Okay. So very often we see parties fighting in court. They might not necessarily fighting for the child, or they may think that they're fighting for a child, but essentially they're fighting for themselves. All right. So it's very important to keep in mind that the court looks at the best interests of the child, not the parties. And the right bottom corner says stability here, because when the court makes decisions, they will tend to think that status quo matters. It's always not in their interest to uproot them, or if there's a drastic change to their living arrangements. So this will be usually one of the criteria when the court makes decisions. They would prefer to keep the same care and living arrangement if possible, because they think that to minimize the change is usually best for them. So we talked about children's arrangement and how the court made the decision, but it won't be completed if you have the child custody without a roof over your head. So it's the second part would be child maintenance. Okay, it's relatively straightforward when compared to the custody and can control orders. Essentially, the two key points, that is, number one, reasonable needs of the child, and number two, the abilities of the parents to pay. Now, let's talk about the ability to pay. Very often, there's a misconception that if I have no income or if I resigned from a job, I can stop paying. But this is not correct. Absolutely no, because what the court looks at is not your actual income, but rather the earning capacity. I have seen way too many cases that they will simply maybe agree to an amount and then later on decides to resign from a job and then apply for variation, right? But the court absolutely despises this, and they will tell to the parties strongly that we are not looking at the actual income, but the earning capacity. Now, another special features in Hong Kong is financial resources. You might not necessarily have income or stable employment, but if there is no stable employment, the court can also look at the financial resources. Say, for example, I have 10 millions as time deposits, right? It's generating some income, but not necessarily employment, salary type of income. But this can be used as or counted as financial resources. And this financial resources expand to third-party supports, which is also very common in Hong Kong. You might have grandparents supporting the grandchild. Now, in that case, the courts are minded or are prepared to make orders against the parents, taking into account the support from their own parents. All right, so let's give an example. The grandparents are very wealthy, all right, and the parents themselves might not have to work. They can live off completely from the financial support of their own parents, all right? And obviously, the parents themselves are using this financial support to pay for the kids. In this case, the family court would be prepared to say, okay, I've looked at the past, throughout the history, the grandparents have always been supporting the grandchildren, all right? I see no reason why this would stop. Then the court is prepared to take into account that as financial resources of the parents and make order. They won't make order against the grandparents because this is a divorce between the parents themselves. But they will still make order against the parents to pay, assuming that parents would have the ability to ask their own parents for help. All right. So when it comes to ability to pay, the court again is prepared to act in the best interest of the child and make sure the kids are protected. Obviously, that is easier said than done because getting the order is only half of the story. Getting the money itself can be difficult. All right. But that is a topic for another day. All right, let's go back to reasonable needs of the child. Reasonable needs of the child can vary. It all depends on the circumstances of the case. If a family has a very high standard of living, then the court would assess the reasonable needs at that standard. Okay, so take it to the extreme. If a family travels 10 times a year, they always fly first class, horse racing, whatnot, then the court is prepared to set the reasonable needs at that standard, and they would allow the kids to continue to travel 10 times a year at business class, 5-star hotels. All right. So it's not rocket science, though. It's very difficult to say, oh, what would be the reasonable needs. And as I said, because kids age, their needs changes. So this also varies. But for this particular purposes, I think we just need to keep in mind that reasonable needs is likely with reference to the standard of living. Now, for average families in Hong Kong, when it comes to a separation, what is inevitable is that the standard of living would usually drop for simple reason that there isn't sufficient financial resources. Imagine that you are all living in one household, and then suddenly the party separates. Then it becomes two households, two rents, which the income might not cover sufficiently. Then what's going to happen is that everyone's standard would have to be dropped in order to, perhaps due to the limitation of their ability to pay. All right. Now, another thing to keep in mind is that unlike children arrangement, that is the care and control custody, which ends at the age of 18, children's maintenance extends beyond the age of 18 to, the law says, completes full-time education, whichever is later. Now, there's a catch here. If the child turns 18 and decides to, I want to take a gap year and work, then technically the maintenance or the requirement to support might cease. So it requires a continuation. You hit 18, you continue to be in school until you complete full-time education. And that full-time education we usually refers to tertiary education, the first degree only. It rarely extends to master's degrees. Okay. Yes, like children arrangements, children's maintenance can also be varied. Okay, so you can imagine the heavy workload of the courts. You deal with the divorce proceedings. You thought you settled children matters and finance. And then, unfortunately, because there is any change to the financial position of the parties or the needs of the child, then they just come back to court and reopen the matter. Okay, so very often you see cases that ended a few years back and now come back to court. When the court looks at variation applications, they are bound to look at the matter afresh. So you have to pretty much redo the whole exercise, look at the needs of the parties, and also their financial abilities. So the whole process takes a very long time. Therefore, the court is prepared to make interim orders. It's not only final orders. You can imagine if the divorce proceedings last for, say, 2 years. What if one party suddenly stopped the financial maintenance? Then you can apply for some interim reliefs pending the determination of the divorce. So this can be quite handy if you are in a tight financial situation. Okay, the last topic I will cover is legal aid. There are different legal aid schemes for different sorts of applications. For matrimonial matters, generally speaking, if you're applying for legal aid, you have to pass 2 tests. One is the merits test, and the other one is means test. Merits test is simply whether you have. It doesn't require a very good case, but at least have a case. Okay, and therefore, legal aid would rarely, I've never seen one being granted for parties to defend a main suit. Okay, but typically when it comes to children matters, they are quite generous. So I've never seen legal aid being rejected because you're trying to defend the children matters. Okay, means test simply refers to the financial limit that you can have. And it doesn't take, at the moment, the amount is $452,320. It doesn't take into account your own flat. So say if you have your own property that you're living in, the legal aid will discount that when calculating the means. But say, for example, I have a property that is generating rental income, then likely than not, you will have you won't meet the requirement because that property itself is likely to worth more than $400,000. And the court, when the legal aid calculate the amount, they will also look at disposable income. So it's not like that. I have no savings. But if you have a lot of income, say I earned 100K per month, but I have no savings, then they will still have to calculate your disposable income for 12 months. So if, say, for example, I earn 100K per month and my monthly expenses is only 30K, I have 70K left per month. And therefore, that you will likely surpass that means test because they do not only look at your savings. Lastly, and probably one of the very important factor is that legal aid is not free. All right, there's some misconceptions that I apply for legal aid, I can do whatever I want, I can take out all sorts of applications. Okay, but legal aid is not free. You are subject to what is called the legal aid first charge. So whatever you manage to recover from the other side or retain, then that legal aid director can get that to pay off whatever legal fees that you have incurred, and you're only entitled to the remaining of that. All right. So it's very important to keep in mind that applying for legal aid does not mean you can do whatever you want. Okay, this is a quick summary that what we have discussed. We've talked about how to invoke or when we can invoke the Hong Kong Family Court's jurisdiction, the definition of children of the family, what care orders the Hong Kong court would make, and the guiding principle being the best interest of the child. And then we also briefly talked about maintenance and lastly on legal aid. Now, if there's anything I want you to take away from this short presentation, it's mainly that the children's orders, keep in mind the custody can control and access, and that the guiding principle is always best interest of the child, not the parents. All right, so if there's any questions from the floor, this is a tricky question because when you talk about special needs, there are different varieties of special needs. I did mention that if that child, perhaps like say for example, is mentally incapacitated and fall under the definition of the MHO, the Mental Health Ordinance, then apart from the divorce jurisdiction, you can obviously invoke the High Court's jurisdiction to ask for maintenance for that child. But I would not necessarily say that because that child has special needs, then the family court would automatically extend that maintenance period. I think the court is quite conservative when it comes to the definition of full-time education. I'm not aware of any case law that is prepared to extend beyond that. But I would definitely look for if you can invoke the High Court's jurisdiction and to get additional financial support from that avenue. I think that is a very good question. But again, I highly doubt if the court is prepared to extend financial support in a divorce context indefinitely. But this is a very good question. Thank you. If it is a child born out of wedlock, then this does not apply. You have to invoke different jurisdiction, but the basic concept of custody can control and access still applies, and the best interest principle still applies, but the jurisdiction, what I've talked about, domicile, substantial connection, none of those applies. Because jurisdiction matters when it comes to a child born out of a wedlock, or if you're invoking a completely different jurisdiction of the court. And the jurisdictional requirement is way smaller. It's very easy to invoke the court's jurisdiction governing a child born out of wedlock. In extreme case, If the child is born in Hong Kong, he might be a Hong Kong citizen. But if the whole family no longer lives in Hong Kong, they can still come back to court and apply for custody, care, and control and access. It's because the jurisdiction under that particular ordinance is very loose. And in a way, you can still argue that, I want to invoke the court's inherent jurisdiction. Now, that is a completely different concept. But to answer your question, perhaps the only thing that applies would be custody, care, and control access and the guiding principle of best interest. But you likely have to not worry about jurisdiction issues. Yes, it does. It generally, for sure, does. And it's not so clear cut as to if I say take a gap year, would that mean there's a discontinuance? Not necessarily. So it all depends on the court's discretionary jurisdiction. It's just that if there is a break, for example, then it attracts arguments. So it's best that the child does continue the education just to avoid this technical arguments. Because the case law doesn't say, if there's a gap year, that automatically severs the parents' liabilities. No, it doesn't say so. Great. Then I will hand the mic to Polly.
Hi, everyone. I'm Polly Chu, real estate lawyer in Hugill and Ip. Thank you for staying for 1.5 hours. This is the last bit, and this is a very important part. Without this part, how can you protect your family, right? So this part, for today's topic, know your rights, protect your families, essentially is the two questions are inseparable for special needs children. The basic question you may ask is, where will my child live and who take care of my home after I'm not able to do it? So the next 20 minutes, I will go through some of the legal tools, which is very essential for helping you to understand how to protect the child. Let's begin with a brief map of where we are going. Essentially, there are 4 planning tools. Wills is basically the foundations of any estate plans. It tells the world who your executors is, how your assets are to be distributed, and essentially it helps to avoid the pitfalls of intestacy. The second one is enduring power of attorneys. With the word enduring, you can imagine this is different from an ordinary power of attorneys. While we talk about the will speaks from the day of death, the EPOA, the enduring power of attorneys, speak during your lifetimes, especially during the period of mental incapacities. We'll go through this more details how it works. And it makes sure that the bills continues to be paid and cares continues to be funded and properties continues to be managed, even if you yourself no longer be able to do it or make decisions during your mental incapacities. The third thing is private trust. It is a more flexible and customized way out of the 4, I would say. A private trust can hold real properties directly and provide your child with a guaranteed long-term residence under professional management. And the 4th one is the government special needs trust, S&T. It is a more affordable cash-only option administered by the Director of Social Welfare Incorporated. I would call it DSWI. And these tools are not mutually exclusive. In fact, the most well-structured plans, they work together quite well. They can be, working together hands in hand. So with an overview of this in mind, I will guide you more details for each of the options. Let's begin with will. A will performs 3 functions. It appoints the executors, it directs how your assets are distributed, and perhaps most importantly, for families in this room, it helps you to avoid intestacy. So why does intestacy matter so much in this context? Because under the successions situations, property can vest directly on a child who, due to cognitive impairment, may simply lack the capacities to sign conveyancing documents. They don't even know what they have been inherited. They don't know how to manage their assets. This is really problematic outcomes, and this certainly you want to avoid. So when it comes to family home, assuming it is a property, a private property, a will essentially gives the executor three ways to do it. One way is the executor can sell the property and distribute the sale proceeds. But then this is a clear and straightforward way, but it does liquidate the family homes. For a special needs child who has lived in that flat for their entire life, they are quite familiar with the neighborhood. They're quite familiar with the door, corridors. To sell the property, it would mean that this is not always the kindest outcome, as I said. So the second way to do it is a direct vesting. The executor transfer the properties to the beneficiaries. The legal difficulty here is that, the beneficiaries might lack the mental capacity, so they cannot simply sign the documents themselves. So while the property seems to be under their name, actually it becomes practically frozen. The third way to do it is offer a life interest to the children, to the beneficiary. But then it also creates a lot of burden to the executors, because the executors has to, hold the property during the lifetime of the beneficiaries. So a few words about stamp duty and cost. While which I know it's sometimes, in front of everybody's mind. The good news is in Hong Kong we don't have estate duty. It was abolished in 2006, and there is no inheritance tax. So there is always no concern about it. And there is also no ad valorem stamp duty if you transfer the property through your will, under your will, to the beneficiaries. The only thing that you bear in mind is about the deed of family arrangement. If you have rescheduled or reallocate the assets of the estate, and you get more out of the will that you're entitled, then the extra bit will attract stamp duty as well. So we talk about the private properties, but actually some of the families lived in subsidized flat. So to deal with that comprehensively, I also talk about subsidized flat as well. There are two options available for the families if they lived in subsidized flat. The only concern is about whether there is any restrictions on alienations, meaning that you have to pay the premium before you sell the properties. So once this premium is paid, you will be free in the market and can sell the properties easily, as if it is a private flat. The only thing the executor is to obtain a grant of probate before it can sell the property in the open market, and there is no stamp duty. And on the other hand, the restrictions has not been lifted, normally you have to apply for approval from the housing authorities. There are two ways. There are two types of flat. One from the housing authority secondary market, which means that you have to get approval from the housing authority before you can sell. The other one is the flat for sale secondary market. Again, you also have to get a prescribed form, pay the administrative fee, get a clearance from the housing authorities before you can sell it. So the takeaway is that, for any transfer, if you need to vest the beneficiary under the will, you require prior approval from the housing authority or housing society. So this is not a formality. Formality is you just have to do it and then to pay the administrative fee. So to sum up for that part, a will is highly tailored. It takes effect only on death and can be amended at any time if you have testamentary capacities. So its main limitation is that it depends entirely on having a trustworthy and capable executors to help you to carry on your wishes and to directly vest the properties and to deal with the asset. That's the downside of it. So the second thing is enduring power of attorney. As I said, a will speaks when you passed away. It only takes effect on death. But what happened if in the years, sometimes decade, between the loss of your mental capacity and death? This is where the EPA comes in. And EPA allows you, as a donor, to appoint one or more attorney to manage your finance if you become mentally incapable. The authority can be very broad. You can tick the box for paying the living expenses and managing investment, selling the properties, etc. And importantly, the EPA can expressly authorize the attorney to apply your asset for the benefit of yourself and also another person, meaning that you can also cover your special needs child, whom you reasonably expected to support. This is a powerful tool because it preserves continuities. Without an EPA, a parent who lose capacities actually can do nothing, but is forced to apply under the mental health ordinance route, which means that you have to go to the court to make an application. It's very lengthy, very expensive, and contain very rigid powers. The amount of money that you can spend a month is very minimal, might not be sufficient to cover the daily expenses as well. So the associate cost compared with the mental health ordinance is the EPOA, enduring power of attorney. The cost is less and is fast. The actual cost that you have to spend is to pay a medical certificate of a doctor to sign and the lawyer's fee to sign, and then the registration fee for high court, which is only $440 for a registration fees. So it's relatively cheaper and easier. So that said, there are real limitations. Every donor must understand, because for EPOA, the donor, when they sign the power of attorney, you must have the mental capacities to do it at the time when you sign. So if you cannot put an EPOA if you lost your mental capacity, it's simply too late. So the second thing about EPA is it will automatically revoke it upon the donor's death, which means the attorney's authorities simply switch off. So from that moment, only an executor under a will or administrator under intestacy can act. This is precisely why an EPOA cannot stand alone. We always advise clients that when you do an EPOA, you have to pair with the will. So thirdly, revocation during lifetime. It can be very expensive because once you register your EPOA in the High Court, if you want to revoke it, you have to go to the court, make an application, do a revocation, and then you will have to do another EPOA again, which means that you have to go to the doctor to sign the documents, the solicitors to sign the documents, then register in the High Court. That is another process. So make sure that you appoint the right person as your attorney and make your right decision to register it, and then that's it. So after that, you might want to look about the EPO, the private trust. So somebody may want to know, apart from will and EPOA, what kind of legal tools might be feasible as well. I would say private trust. It is the most powerful tool in the toolbox for families with where you have a significant real estate. The structure are commonly used as using a discretionary family trust. So the trustee actually holds full discretion over distributions of income and capital among a defined class of beneficiaries. The beneficiaries themselves have no fixed entitlement. They're only entitled to receive distributions if and when the trustee, exercising its discretions, decides in their favor. This may sound restrictive, but it is precisely the flexibility that allow the trust to respond to a beneficiary's changing medical care and housing needs over time. Because at the time when you set up the trust, And then at the time when it goes by, there are increasing demands or costs for medical and care. So the discretionary trust will come into play to allow the trustee some kind of flexibilities. So to be valid, every private trust needs three certainty. Certainty of intention. There must be a clear intention to create a trust, not merely a moral wish or expectations. The second certainty is certainty of subject matter. The trust property must be clearly identified. For example, flat 8 on the 12th floor ABC building. Certainty of object is the third certainty. You must have a certainty of the beneficiaries or the class of beneficiaries. They must be must be identifiable. So where private trust truly shines for our families is direct holding of the real properties. Real estate can be placed into the trust and benefits are tangible. It provides a guaranteed long-term residence for the child. The trustees insures the properties and where appropriate may rent it out and with the rental incomes to fund the care. And because the assets are held in trust as well, they pass outside probate. So you don't need to do the probate. There is no interruptions. There's no gap. So care arrangement can be made seamlessly on the parent's death. There are a lot of key advantages for having a private trust. Number one is professional management. A trust managed by a professional trustee or a private trust company offers a layer of protection against mismanagement because they're for professionals. So against family disputes and exploitations, concerns that sadly are not theoretical in our daily lives. Secondly is tax efficiency. Hong Kong has no estate duty, no inheritance tax, and no capital gain tax, no gift tax. So equally important, trust assets do not affect disability allowance eligibilities, which is not means tested. Thirdly is the long-term continuities. Following to 2013's reforms, the rule against perpetuities was largely abolished in Hong Kong, and trusts may now exist immediately. For special needs beneficiaries who may outlive their parents by 40 or 50 years, this is invaluable. So the fourth one is asset protections. Assets in a properly structured discretionary trust are generally insulated from the settlor's personal creditors and afford some protections against certain matrimonial claims, subject, of course, to anti-avoidance rules. Fifth is confidentialities. The trust arrangements are entirely private. Under a will, which becomes a public document on probate, there is no public register of private trust in Hong Kong, so it can preserve confidentialities. And the fifth one, perhaps the most meaningful one, housing security. The trustee can grant the child an express right to live and to occupy the property for life, while still giving the trustee the flexibility to sell and replace the property if circumstances change. For example, moving to barrier-free accommodations as needs evolve. So of course, no planning is without trade-off. So we will have to understand some of the trade-off as well. When transferring real property, essentially there are two options that you can choose. One is lifetime transfer. The other one is post-death transfer. If you do a lifetime transfer and make sure that if the property is mortgaged, you might have to think about the lender's consent, refinancing before you inject the property into the trust. And there are, of course, legal fees and registration fees. And more importantly, when you inject your property into the trust, there will be ad valorem stamp duty. And this is assessed based on the market values of the properties, which essentially a lot of them may have such a big concern. The other way is post-death transfer, meaning that you transfer the properties after death. So there is no stamp duty because you do it according to the will. And the downside is you have to wait until the grant of probate is issued before you can do all these formalities. So during the gap between obtaining the grant of probate and the transfer of the property into the trust, there is a gap period. So during that period, you might not have special clause or dealing with the child's home or a particular interest of the child. So for that part, you have to take care maybe in your will to make some kind of interim measures. So that's why we said all of these tools are hands in hands. You have to think about one thing and then timeline and then the other things together. Yeah. So this one, Government Special Needs Trust. I think some of them may ask these questions earlier about it. I can briefly talk about it. It was established in December 2018 with the Director of Social Welfare Incorporated as the trustee. The SNT was designated for families after the parents' death. Actually, they manage the cash assets and disperse funds to designated carer in line with the care plans. So the eligibility requirements are set out clearly in the guidelines. The settlor must be the parents or relatives. It must be a Hong Kong permanent resident aged 18 or above and not an undischarged bankrupt. For the beneficiary, it must have an intellectual disability, for example, Down syndrome or mental disorder or autism, and must be a Hong Kong permanent resident ordinary residing here. So you must also prepare a care plan and sign a letter of intent. And there is an annual fee of $20,000 per trust account. So, but I must draw your attention to the scheme. For this scheme, one limitation, which is very important, is that they only accept cash in Hong Kong dollars and no other currency. So if you have real property, you must be liquidate the property first before you can inject the cash into this fund. So for some of the families, they might have to think about it, because the family home is maybe their only asset. So the advantages are significant. It is considerably cheaper than a private trust. It provides affordable financial planning. And the beauty of it is the registered social worker is appointed as case manager and to oversee your child's needs over time. But there are disadvantages. As I said, they only accept cash only, Hong Kong dollars. And so it has to force you to liquidate your family's home. The setup time is quite lengthy because normally the social welfare workers have to work out the care plan carefully and to budget the amount of money that the child might need over time. So it might take months. Exhaustion risk as well. This is crucial. If your executors take a lot of time to deal with the probate, the initial trust fund may be exhausted before the additional funds can be injected. And in that situation, the SNT will be terminated with no possibility of reactivations. So my professional advice to the parents are they have to prepare not only the first payment and the annual fee for the first year's trust fee, but give some buffer for the time that they need to do for applying for the probate and to bridge the gap. So essentially, it's not just 6 months preparation and trustee fee, but maybe a year's more time for to prepare for that budget. Almost close to the end, trust and public housing. This is crucial because I want to spend a little bit of time on that as well. Family, because they often overlook until it is too late. So how trust and property ownership interact with public and subsidized housing. So for families whose child lives in public housing, government SNT would help you to fund the daily expenses, but it will not disrupt your tenancy. But then for private trust paying regular income to or for the benefit of the beneficiaries, it will hit the means tax, which means that potentially it will breach the income or asset limit and trigger some kind of reassessment. So one thing to be mindful is if you do all these kind of estate planning, make sure that the plans that you choose would not trigger any breach of the subsidized housing or benefits the child can enjoy. So this one is should be very careful. And there are some schemes that housing authorities provide. There is a harmonious family priority schemes. It offers priorities for families living with or near dependent relatives, including special needs adults. This is a meaningful benefit for many of you in this room. Maybe for HOS and green farm subsidized home ownership, there is no such special priority for special needs families. So although general priority categories may apply depending on household compositions. So one thing to remind you is professional legal advice is essential because one choose link up with others and may prejudice the other. Okay. So some takeaway here. So for will, it is a foundations. It appoints your executors and direct distributions and avoids the harshness of intestacy. And for enduring POA, it will endure continuities of financial support and property management during your incapacities, but it ceases on death. So which is why it must be paired with will. The third one is private trust. It offers professional management, asset protections, and guarantee long-term housing. So although it comes up with some setup cost and in case of lifetime transfer at valorem stamp duty, the fourth one is government S&T. It provides an affordable cash-only solutions managed by DSWI to fund the daily care, but it requires liquidation of real estate injections. Finally, trust distributions and property ownership, they must be carefully structured to avoid disqualifying your child from public housing and other subsidized benefit. So ladies and gentlemen, the single message that I would ask you to carry home is you do have options. And the law in Hong Kong, used thoroughly and combined wisely, can give your family genuine peace of mind. Every family is different. The right plan for your family is the one designated around your child, around your asset, and around your families. And the people you trust will be able to carry your wishes forward. There is no one off-the-shelf answer, but with proper advice, there is almost always a workable answer.
In Hong Kong, there's more insurance products now that have many trust functions. Would you be able to share what you think about those in comparisons to say like wills or private trusts?
I think the tools that we talk about is some of the legal tools that we company come across, but we work closely with insurance company as well because sometimes insurance product do help because it gives you an immediate urgency money without going through the probate. So we do this hand in hand, but of course for insurance, you cannot do everything. It can only be limited by the kind of policy the insurance company offers and for example, like properties that you won't be able to allow them to manage it, or for special needs care plans, they won't be able to do it. What they do is the money terms, sorry. So every tools have their benefits and you have to, structures together. Yeah, that's my advice. Thank you.